Hi, and welcome to this webinar about all things GDPR when it comes to Pipedrive and your relationship with Pipedrive. My name is Martin. I'm the Data Protection Officer for Pipedrive, which means that it is my full-time job to make sure that personal data gets the attention and the protection that it deserves. Today, we will be addressing 6 topics that were mentioned in the questionnaire that you likely replied to. I was hoping for the questionnaire to narrow things down, but in reality, all 6 topics were mentioned and requested quite at the same level. So I will try to cover all topics, even though I could probably have a discussion with you for half an hour on each of these topics. We will start with the terms used in the GDPR and the roles related to the processing of personal data in your use of Pipedrive. That will be followed by an overview of what a data processing agreement is and what topics and what provisions it needs to cover. This will be followed by an overview of legal basis for processing. This includes consent, which is also a very hot topic among our customers. And then we'll talk about how to actually comply with the GDPR when using Pipedrive. So how can you make best use of the app to make sure that you meet the requirements. And then I'll explain the situation about data transfers, which our customers often ask questions about, and very rightfully so. And we will wrap it up with GDPR compliance in general, what it is, and what can be done to achieve compliance. So, data subject, the controller, and the processor. Who's who under the GDPR when using Pipedrive?
Before we go into the specifics of the relationships between the data subject and the controller and the processor, let's really quickly take a look at GDPR in general, because there were a few questions about what GDPR is and just remarks of being confused. So the GDPR, that is the General Data Protection Regulation, is a European law that is directly applicable in all member states. As a regulation, countries don't need to adopt their own laws for the provisions to be enforceable. The GDPR is designed to protect the data subject, and its second aim is to harmonize the data protection requirements across the EU. So, who does it apply to? Well, essentially, the answer is to everyone who is processing personal data. Larger companies compared to smaller companies have a few additional obligations, like appointing a data protection officer who would be the contact or liaison between the data subject and the controller, or as a processor, it will also involve handling the relationship with the controller. And also larger companies have to maintain a document called the records of processing activities, which explain how the data moves inside the company and what sort of data is processed by the company. Now, let's take a look at the roles and relationships in the context of the GDPR when using Pipedrive. The first participant in the chain of events is the data subject. So this is the person about whom the data is. And then we have a controller who likely collects the data from the data subject, or could collect it from another source if they meet the obligation to inform the data subject afterwards. And in turn, the data controller might decide that some of the processing operations are better conducted by a data processor. So they engage a processor to perform some of the actions on their behalf. And in some cases, the data processor might have a data subprocessor to perform some of the actions on their behalf in turn. So how does this relate to your use of Pipedrive? Well, the largest set of personal data in Pipedrive is actually about your customers. So your customers here are the data subjects, and you are the data controller. So you collect the information from them, and you decide to use that information for your sales and marketing activities. In turn, you have probably realized that managing this information on your own is quite a challenging thing to do. So you have engaged a data processor in Pipedrive to organize the data on your behalf, so you could schedule activities and have email conversations in one place and so on. So Pipedrive acts as the data processor. The relationship between the data controller and the processor is very well defined in the GDPR, and we will talk about this in the section about the data processing agreement as well. But in general, you should know that the data controller has most of the obligations under the GDPR, so the obligation to inform the data subject about the processing activities, the obligation to comply with the data subject's requests, and also the obligation to make sure that you have a legal basis for processing the data. The processor's obligations are mainly twofold. First of all, they have to keep the data safe and secure, and Pipedrive does this by maintaining very high security standards. The second obligation is to follow the instructions of the controller, and this we also do with very rigorous processes that make sure that we do not touch the data that concerns your customers, the data subjects, without specific instructions from you. And now, in turn, because Pipedrive does not have all the services in-house, we might engage a sub-processor, and we've done this, for example, with Rackspace and Amazon Web Services, who provide hosting services for us. So this is the chain of custody of personal data when it comes to your customers as data subjects. But there's also another set of data subjects in your relationship with Pipedrive, and that is actually you. This means that we are the controller because we collect the information from you and about you. For example, we collect your email address so we could allow you to log in with that email address. And also, if you've so chosen, we can send you marketing information. And so we also collect your billing data, for example, so you can pay for the subscription. So Pipedrive in that situation is a data controller and might in turn use a data processor. For example, we use MailChimp for some of our emailing activities that perform these actions on our behalf. So this is what the relationships look like when it comes to your use of Pipedrive. Now let's take a look at what constitutes a data processing agreement.
Well, Article 28, Section 3 of the GDPR says that a data processing agreement is a binding contract between the controller and the processor. Before I move on to the details, I really quickly want to show you a resource that I use quite often. It's a website called gdpr-info.eu. Here you can have a more convenient way of looking at the text of the GDPR. It's divided into chapters, and you can also search for keywords and search for the terms here. So very convenient. I use it all the time. Okay, let's jump back to the presentation now. So as I said, a binding contract between the controller and processor. So the emphasis is on the word binding. You need to have this with every processor you engage as a controller. So Pipedrive is one of the processors for the data that you collected about your potential customers or existing customers, and you might have other service providers or other services that you use where you put in your client data, and they should also be offering a DPA to you if they haven't already. The DPA contains provisions that explain the subject matter, the duration, the nature, and the purpose of processing, and it also describes what type of data you collect and the categories of data subjects involved. So it's a very general description, but it should be included in the DPA. Otherwise, it will not meet GDPR requirements. And in a more general way, the DPA just explains the obligations and the rights of both the controller and the processor with regard to processing the data that is covered by that DPA. To make life easier, the legislator has actually given you a list of provisions that the DPA must contain. This is provided in subsections of Article 28, Section 3. It's quite convenient to simply open the text of the law, for example, using the website that I just showed you, and make sure that whatever legal documents that you have with your processor contains these provisions. And a more interesting topic for us as an online service provider is Article 28, Section 9, which says that the data processing agreement needs to be in writing, but it also expressly states that it can be in electronic form. So what does this mean for us, and what does this mean for you? I would like to interpret it as allowing operation under a terms of service. So software as a service nowadays with service providers that have tens of thousands of customers, maybe even millions, operating in any other way would be very, very difficult for them. It's likely an administrative burden that can't be managed. So I would like to see that the GDPR is interpreted in a way that this electronic form requirement also covers the working based on the terms of service. But we've had many requests from our customers for a signed data processing addendum. So in light of this, we have provided the a signed document for your convenience, But we would like to hope that in the future the authorities understand that this additional requirement really isn't in the GDPR, and we could operate based on the terms of service, which is more convenient for our customers and also more convenient for us, as long as the terms of service cover the requirements of the GDPR, especially Article 28, Section 3. This is why actually we updated our terms of service and privacy policy in March. Now, let's talk about a very interesting topic called the legal basis for processing and the hot question of, do I need consent? I'm sure you've seen many of these emails flying around different companies and service providers asking for consent in order to continue their marketing efforts. For legal basis, the GDPR lists options in Article 6. For private companies, some of those options are more relevant than others. And it starts out with consent. When talking about consent, you should always refer to Article 4, Section 11, which actually explains what counts as consent. This is one of the major changes of the GDPR. So anything that is pre-ticked, does not require an affirmative, specific, unambiguous action by the user, likely does not count as consent. So consent is a tricky thing to get. You should keep these requirements in mind when you want to operate based on consent. The question is, do you always want to operate based on consent? Because there are other legal bases that are likely available to you. My favorite legal basis is that the information, the processing of that personal data is required or necessary for the contract with the data subject. A simple example would be that if you're delivering something to an individual, a customer, then you need their address in order to deliver that product or service. So for that information, you do not need consent. If you limit your information, the information that you gather to this requirement, then you don't actually need to rely on consent, which is great for you because consent is a difficult thing to manage. Also, there's another option, and this is often called the problem child of the GDPR, but at the same time, it might be the savior of the GDPR because it allows businesses to actually conduct their operations in a reasonable manner. So what is a legitimate interest? Well, as a private company, it's completely okay for you to want to sell your product, for you to want to make sure that your systems are safe and so on. So security is a legitimate interest and product development is a legitimate interest. There's also a specific mention to marketing being a legitimate interest in the GDPR, but this has certain limitations, which we will also discuss later on. So, as a controller, what does all this mean for you? First of all, minimize the data. Get only what you actually need for the contract or what you can reasonably justify as a legitimate interest. So if you can do this, you don't need to rely on consent. And this is the ideal situation for you. With legitimate interest, of course, you always need to balance your legitimate interest in performing certain data processing activities against the rights of the individual to be left alone, the person's interest in privacy. Second, you need to understand when your legal basis expires. So if you're working based on a contract, you can define it as when the contract ends or a certain period after that, when you no longer need to conduct follow-up activities. And you define that period and you make sure processes are in place to remove the data once you no longer have this legal basis. Same thing with the legitimate interest. You need to justify that your legitimate interest is valid for a certain period, that you need this data to serve that interest, and once that period expires, you should organize the deletion of the data. So again, and just referring back to the legal basis that you're processing for the contract or to prepare for the contract with the data subject, that you have a legitimate interest, always weigh it against the data subject's rights and justify it. You need to document this. This is one of the requirements of the GDPR. This goes in line with the accountability requirement. And let's also talk about marketing as a legitimate interest really quickly. The GDPR affirms marketing as a legitimate interest in recital 47, but this has been limited in subsequent laws. For example, in the UK, I believe the law is called the PECR, where it is stated that this legitimate interest is valid only for clients whose data you obtained in the course of a sale, so only for individuals whose data you got when you sold a product or a service to them. This means essentially that you have the right to do upselling, but not cold emailing or cold calling as such. I believe the idea here is that you have reason to believe that the person is interested in your product. And if you're sending them an email and the person is interested, then they will likely not feel that their privacy has been violated. So just keep that in mind when doing marketing based on legitimate interest. And of course, with consent, the tricky thing isn't really getting consent. You can ask for consent. It's very specific how you do it. But in terms of administrative work, you have to be able to manage it, document it, that you received it on that date for those purposes. And also, you need to be ready for the data subject to actually revoke their consent, which means that you will need to stop processing the personal data. This doesn't mean that any actions you did before the consent was revoked, that those are somehow illegal. That's not the case, but you just need to stop processing the personal data. And finally, make sure you clean up regularly. This means that you understand what data you need and what data you no longer need, and you check this regularly. This depends on how long your sales cycle is. For some people, it might be that a lead is so cold that it will never be contacted again if it hasn't been touched for a month. For longer sales cycles, it might be a year. So it's up to you to define this and document this. And finally, last but not least, really, we'll also talk about breach notifications, which were also asked in the free-form field of the questionnaire. With breach notifications, there's a certain process to it, and you can find it in the GDPR as well. But basically, you need to identify whether the breach was actually a breach of personal data, and if and when you understand that this results in a risk to the rights of the individual, or rights of the data subject, then you need to notify the authorities within 72 hours. So, and the points that need to be included in the notification are also stated in the law. So you can use the website that I gave you to find that specific provision. So, more specific examples on how to comply with the GDPR when using Pipedrive. Minimization. Get only the data that you need. Simple enough, isn't it? So you have probably custom fields in Pipedrive. You're filling in some information about your customer. Take a hard look at what fields you have and whether you're actually using those that information and whether you actually need it. And minimization. Simple enough. Get only the data that you need. You have the option to create custom fields in Pipedrive, so you can add a lot of information about your customer in the app. But you should carefully consider what you actually need, and just don't collect the information that your salespeople are not using. So, and you can already take a look at your existing fields and see and ask your salespeople what they actually use in their sales process. How can you understand the legal basis when putting data into Pipedrive, and how you can document this? Also easy. Custom fields help you out here. So you can create a custom field to mark the legal basis for processing a certain contact data. If you want to keep track of this, you could add options that consent or legitimate interest, or that you collected the data for the purpose of the contract, and so on. Also, you can document the consent using web forms, Or if you don't use the web forms, you can do it manually, but it's really convenient using the web forms feature. And I just quickly want to show you what you can do. So we are in Pipedrive in the settings page, customize fields section, and you can simply go to the people tab and create some sort of consent field. I've used the multiple options field, and you just add whatever they agree to. It can also just have one option that they consent to marketing communications, for example. And then I also wanted to quickly show you how to do this in the web forms, because you can reuse the same field if you're looking at the web forms, and you can ask a person to check the boxes if they would like to hear from you. And also, if you embed the web form into your website, you could actually have your terms of service and privacy policy in the footer and refer to this. Let me just really quickly show you what this page looks like in the web form. Yeah, so this obviously will contain more information for you, but they fill in those fields. You can mark them as required, and then the last one is here. And if they tick the boxes, then the contact that is generated in Pipedrive will have these options marked, so your salespeople know what to do and what they are allowed to do. So yeah, back to the presentation. Other things you can do in Pipedrive in line with the GDPR. A hot topic, a very important topic, is deletion. You should definitely come up with criteria when you no longer need a contact person's data. And the best way to do this for you is actually set up a filter for this. You can create a filter in Pipedrive based on when the last activity was scheduled with the person, or whether they have an open deal with you in Pipedrive. So it's easy to find people that should be deleted using the filters. And when you do find these contacts, you can mark them as deleted at first. I will emphasize that this doesn't actually permanently delete the contact, but it just makes it so that the users don't see the contact. And if you do need to permanently delete the data, then ask customer support to permanently delete the data. We have support engineers who will do this without delay. They're quite responsive, I might say. And I just wanted to quickly explain why we're still having customers do this through support, is that we're getting a lot of cases, more cases about accidental deletions than we are getting cases for deletion requests, at least for now. So customer support, and specifically the support engineers, have asked us to keep this process as a control mechanism. But they will be very responsive when we get any requests to delete data. And one more topic that is very interesting under the GDPR is suppression. And this came up in the questionnaire as well, that if a person comes to you and says that I no longer want to receive any communications from you, then actually deleting all of their data might be counterproductive, because that won't prevent the user from being included in your mailing list or in your data in the future, because you no longer know that they declined these communications. So when a data subject requests for their data to be deleted, it's okay to communicate with them and to understand what their aim is. If their aim is suppression, then you might actually delete all the rest of the data, just keep the fact that this person with this email or this phone number asked not to be contacted again. It is completely acceptable to clarify the situation with the customer. If they still want you to permanently delete their data, then just come to support and we will help you out. Now, you also might get data subject access requests, which are basically, simply put, a data subject wanting to know what information you have about them. And in my opinion, the most convenient way of doing this is actually printing the details page for the customer into a PDF file and sharing this with them. Because this will actually give them a contextual overview of the data that you have about them. Let me really quickly show you what I mean in the Pipedrive app as well. So here we have John Connor, a contact in my test account, and I have an email attached to them and some activities listed and so on. You just select all here. You should expand the emails, make sure all the body is visible, and you can simply print this page into a PDF file, which will give them a nice overview of all the data that you have about them. Now, it is also possible that the person wants you to give them the data in a form that would allow them to upload that data into another service. So you can still generate an export file where all the fields that you've created and you've filled for the customer are shown, and you can export the notes attached to the contact and the activities and so on. But in all likelihood, if the person wants an overview, printing the details page is actually a more convenient way of doing things. The GDPR has strict requirements for data transfers.
So what does the GDPR say about data transfers? Well, transfers outside the European Economic Area are basically prohibited unless appropriate safeguards are in place to protect personal data. So this is regulated in Articles 44 to 50. While this makes things more complicated, it does not mean that transfers are completely prohibited, as you can see. So why is the GDPR so strict on data transfers? Well, it makes perfect sense. Because if we provide protection to personal data within the scope, then we can't make it easy to move the data outside the scope of the GDPR. Otherwise, the protection that we provide would be meaningless. So what's the situation with data transfers when you are using Pipedrive? As you can see on this slide, I've marked Pipedrive's offices in Tallinn and in London and in New York. And as EU customers, here you are, the stars. You have a relationship with one of the offices in Europe. UK customers have a relationship with Pipedrive in London, and the rest of the EU have a relationship with our Estonian entity. So you provide the data to another EU entity. So no data transfer outside the European Economic Area takes place as a part of this relationship. Then Pipedrive stores this information in our brand new data center in Frankfurt. Now, most of the information that is your main database is stored in Frankfurt. However, there are some service providers that are based in the US that we would also like to use. And they provide valuable services to Pipedrive. For example, you have Google Maps there, which converts the addresses that you put into the address field into Google Maps links. Quite convenient, right? So what do we do about this? We make sure that the service providers that we have in the US are Privacy Shield certified. Privacy Shield is a framework, an agreement between the EU and the US, where US companies can certify themselves and make certain commitments to protect personal data when they handle it, when it's exported from the EU. So we've chosen providers that are Privacy Shield certified, which makes the data transfers acceptable under the GDPR. With that covered, we'll get to the final topic, which is GDPR compliance in general.
This one is a really broad topic that is difficult to define. Using the term compliance in the context of the GDPR is a difficult thing. It is often too vague to help or too specific to really cover everything. What I mean by this is that GDPR isn't like a security standard, for example, SOC 2 or ISO 27001, where you check things off and audit everything and you can be done with it and sure that you're meeting the requirements once the audit is done. The GDPR does invite authorities and countries and member states to come up with certification mechanisms that would prove that a company complies with the GDPR, but so far no such frameworks exist. So it is difficult to understand what company or which company is GDPR compliant, and it is also difficult for companies to prove that they're GDPR compliant. So what can you do to be GDPR compliant? Well, as I don't expect everyone to know all 99 articles by heart, I believe that internalizing the principles of the GDPR in Article 5, that means really understanding them and understanding them from the perspective of the data subject, what the value is for the individual, will allow you to conduct your business in a way that will likely be in line with the GDPR and will likely not get you in the crosshairs of the authorities. Secondly, you should create processes that allow you to protect the data subject. This means that you have a process to make sure that the data that you collect is minimum, that you have data retention periods set in place, and you know how to communicate with the data subject to help them exercise their rights, whether it is access or deletion. So it is very much about communication with the data subject. As long as they are content, you will likely not become subject to an investigation by the authorities. And one of the more difficult things to do if you're getting data from many places is documenting the data flows. So understand where your sources are, understand what third parties you use, and who gets what information from you. Having this overview will help you identify potential areas of risk and things that you might need to remedy. For example, by concluding a data processing agreement that explains how the data is protected and what the processor does on your behalf. So this is what every company should be doing. Nowadays, everyone uses many tools, many service providers. So checking how they relate to the GDPR and what they've done for the GDPR is really important for you as the data controller, because in the end, you might be held responsible for the data if you choose a service provider that doesn't meet GDPR requirements.
So this is it in a nutshell. We could have a webinar on each of these topics separately, but I didn't want to drag this one out too long. If you want more detailed information on sales-related activities in the context of the GDPR, you're also welcome to visit our blog, where our content team has produced some really good materials. Thank you again, and have a great 25th of May.